Now call the second case on this morning's docket, case number 116469, Warren D. Meats Jr. v. Kansas Department of Revenue.
May it please the Court, I'm Assistant Solicitor General Dwight Carswell, appearing on behalf of the Department of Revenue. I'd like to reserve 3 minutes for rebuttal.
Counsel, let's take a minute until Justice Biles says that he's ready.
Oh, go ahead. Thank you.
All right, please proceed.
I'd like to reserve 3 minutes for rebuttal.
3 minutes is granted.
Thank you. In this case, Warren Meats was arrested for DUI while driving away from a bar on St. Patrick's Day. The arresting officer provided Meats with the form DC 70, which advised him that he could face certain criminal penalties if he refused a test to determine his blood alcohol content and had a prior refusal of an evidentiary test. The first issue that Meats cross appeals is whether that warning substantially complies with the statute. The officer then provided a form DC 27, which notified Meats of the suspension of his driver's license and the process for obtaining a hearing. The second cross appeal issue is whether that form was properly served. Meats then requested a hearing, and to obtain that hearing, paid a $50 fee required by KSA 8-1020D. On judicial review, he argued that that fee was unconstitutional. The district court agreed because the fee didn't have any exemption for indigent drivers, and that's the issue that the state's appealing here. On that issue, the district court should have dismissed Meats' constitutional challenge for lack of standing.
Before we go there, that wasn't the basis for the district court's upholding the suspension, was it?
No, that $50 fee had nothing to do with the suspension itself. That was a different finding about the fee being unconstitutional for future cases.
But the issue before the court was a challenge to the administrative suspension of Mr. Meats' driver's license.
That was one of the issues. The other issue was the constitutionality of the fee. And to your earlier question about whether that was dicta or not, what the district court said is, I find this as moot with respect to Meats, but a mootness exception applies because it's capable of repetition yet evading review. Now, we disagree with that, but I don't think that's dicta. Oftentimes when something's moot, yes, it doesn't have any effect on that case. That's what mootness means. But the court can nevertheless address it if a mootness exception applies.
But my question is if the court decided the case based on mootness, then why wasn't the additional ruling or district court's soliloquy about the constitutionality simply dictum? And if it's dictum, why do you have we have a long argument on standing? Why don't you have the same problem from KDR? If you won, you won. And why can you appeal to get the win on the basis that you want to win on?
Well, we didn't win on that issue. The district court, finding it was moot with respect to Meats, struck it down for future cases, said I find this fee is unconstitutional.
But he found it was that he paid the fee, made it moot, and so the suspension was upheld.
The suspension was upheld. The district court found that
the bottom line is Meats is suspended today.
Meats is suspended.
Meats is suspended today, and so the KDR got, well, he was suspended.
Yes.
He did his full suspension, or whatever, but there was no ruling that cut off his suspension, correct?
Technically it's a suspension has stayed, but yes, the issues he cross appeals would affect his suspension. The $50 fee issue doesn't affect the suspension, but I don't think it's dicta because the district court held that fee was unconstitutional going forward. Just like when this court, did you have a question?
Well, I think, yeah. Your basic point is that mootness didn't prevent review because he applied an exception. That's your basic
We disagree with that, but yes, that's exactly.
I understand
yes.
that, but you're saying he did reach the issue
yes,
of constitutionality. Exactly. I'm confused about mootness as to this license holder anyway because he paid the fee. So, the fee was applied to him, and whether he had to pay it or not seems to put it in issue. That's where I'm confused. So if you want to proceed with your standing argument.
Well, I'll address that very quickly.
Yeah,
on
that
that issue,
doesn't that give him
Counsel?
standing?
I'm not able to hear your arguments when you're speaking over top of my colleague. So if you'd like my full attention and ability to understand it, let her finish her question, and then we'll give you a chance to respond. Fair enough?
Okay, sure, sorry.
That's okay. So that's my question. Why doesn't that give him standing? He paid the fee. He's out $50.
Well,
Why doesn't it give him standing?
Well, he paid the fee, but he doesn't allege, or at least the district court didn't find that the fee was unconstitutional as applied to him. And in Cross versus Department of Revenue, this court held that if there's no constitutional problem with the application of a statute to a particular litigant, that litigant doesn't have standing to address the statute as applied to third parties, not before the court. The district court's constitutional problem was only, as the court found it, was only applying the fee to indigent individuals.
But that's not his argument. His argument was also that he paid a fee that was non-refundable. The fact that the district court honed in on the indigency problem doesn't mean we can't find the district court correct for an incorrect reason.
Well, I mean, that's the only basis that the district court found, and he's not cross-appealing that other theory about the unconstitutionality. That's not part of his cross-appeal. So the only issue, as I see it before the court, is whether the fee is unconstitutional.
If we agree with you that Judge Moriarty was wrong in finding it was unconstitutional for the reason that he found, but we believe it's unconstitutional for another reason, we're precluded from saying that?
That's not before this court because, yes, that's not part of the cross-appeal section of his brief. And
But that's what the driver argued.
He mentioned that below, but the district court didn't agree with that, didn't address that issue. And so if he wanted to bring that before this court, he had to include that as part of his cross-appeal, which he didn't do. So the only issue is
I thought I read that in his brief.
He may have put it in the direct appeal portion of his brief, not the cross-appeal part. The cross-appeal is limited to the DC-70 and DC-27 issues. So I don't think those theories are before the court.
So he has to cross-appeal if he wins on the unconstitutionality and say, cross-appeal, we want additional reasons why it was unconstitutional?
Well,
unconstitutional when the issue of the constitutionality is brought here by you.
I mean, again, the district court only found it was unconstitutional as applied to indigent drivers. Now, it struck down the statute facially as I read the decision, but that was the limit of the court's unconstitutional finding. So if he wanted to make a broader theory, and that would be a broader theory, it's a facial attack versus an as applied to indigent drivers, he would need to, yes, include that as part of his cross-appeal in the state's view. So in addition to the fact that Meads lacks standing under this court's decision in Cross, the fee is also constitutional, and the district court erred in finding otherwise. In Logan v. Zimmerman-Bresch, the U.S. Supreme Court indicated that filing fees for triggering the right to an adjudication are consistent with due process in appropriate cases, and the court cited United States v. Crass in support. Crass itself is part of a line of cases that establish that filing fees, waivers for indigent individuals are required only when a fundamental right is at stake. Here, driving is not a fundamental right, as this court has previously held. And
when does we've always, and I guess you maintain that driving's more of a privilege rather than a right. Certainly, that's what we found. But when does privilege kind of go in, or privilege kind of merge into necessity, then into a fundamental right? Clearly, the way our society operates, in most instances, driving for most adults could be considered a necessity anyway. Is there any point where that would be kind of head towards a fundamental right? Or counsel in the last case talked about how his clients would rather serve jail time than lose their driver's license because of the necessity to drive. And I think that's probably more true in rural types of environments and where there isn't public transportation. Yes, I understand it's a privilege, but isn't it more than that?
I mean, I certainly think it's a very important privilege, but in order to be a fundamental right, and again, this is U.S. Supreme Court,
I understand.
It has to be so deeply rooted in our history and tradition that without it, liberty and justice would not exist. That's the Supreme Court's framework for fundamental. That's a very high standard, and
Yeah.
driving, while important, is just not there yet. Anyway, so. And because it's not a fundamental right, all that's required is a rational justification. Here, that's the ability to recoup part of the cost of the hearing. And so the fee is constitutional, even as applied to indigent drivers.
Is that rational if the driver wins?
The hearing still occurs, so yes, there'd still be that cost for the
Sure,
hearing.
but is it rational to impose that cost on the innocent party? Is that rational, even if we are in rational basis review?
I mean, rational basis review is very deferential, and yes, I do think because there's that cost to the department that wouldn't have occurred if this situation
Well,
didn't happen.
I agree with that, but that doesn't help me with the question of whether it's rational to force an innocent party to bear that cost. I certainly think it makes eminent sense to say when you avail yourself of the adjudicative process and you lose, there may be some court costs or fees associated with that.
Yeah, I mean, again, I think given the deferential basis of rational
Well, whether
basis
or not
review,
we give deference doesn't at all address the rationality of the government's choice to impose that burden on the innocent litigant.
well, I mean, breaking down rational basis review, there has to be a legitimate government interest. Certainly, recovering the cost of the hearing is that, and then this is
Is it legitimate to recover costs against an innocent party? Is that a legitimate government interest?
yes, I think so.
How? I'm struggling with that.
Because I mean, even if there might be some technicality or something, or the officer made a mistake, there's still this cost that the government incurs because of this situation.
Well, let's
Because the
assume,
person is-
let's just take it out of I mean, imagine the sort of worst case you can imagine of utter innocence on the part of the citizen and utter incompetence or bad faith on the part of the government.
I mean,
How is
certainly-
it rational or legitimate for the government to recoup its costs in that situation?
I mean, certainly, if it's a really extreme situation, there's a constitutional violation. The person could sue, and I mean, there'd be qualified immunity you'd have to get past. But if it's a really extreme situation, that would be very extreme. There is a process, but when the officer just made a mistake or there was some problem like that, there's still the cost to the state that the state has a legitimate interest in recovering at least part of that.
What if,
Especially,
well, that's, not to push the point too far, but under that rationale, it would seem to me that the state could just reach out into anybody's pocketbook and say, well, it's legitimate. We had this expense, so somebody has to pay it.
well, I don't think they could just target a random person.
Well,
to
then
pay.
why can they
Well,
target the innocent litigant?
Because it's that person who's requesting the
It's
hearing.
that person who
that's-
was innocent
that person who's causing the state to have this hearing that has the cost.
to vindicate their innocent status.
Yes. No, I mean, I do think it would be rational if across the board the legislature said, we're going to impose a tax for this, and then everyone's paying for it. But rather than doing that, they decided to impose this $50 fee, which is rational. I'm sure that doesn't even come close to covering all the cost of the hearing, just to defray some of that cost at least. Finally, on this point, even if assuming the statute was unconstitutional as applied to indigent individuals, the proper remedy should be limited to declaring it unconstitutional just in those circumstances, not across the board, as the district courts seem to do. After all, normally when there's a constitutional problem, you limit the solution to the problem, unless there's a non-severability clause or some reason to believe that the legislature would have wanted the entire provision to go away. In Bodie v. Connecticut, for instance, there the U.S. Supreme Court held that a fee was unconstitutional for filing for divorce. They didn't strike down the entire fee, just as applied to those indigent people. I would like to briefly address the DC 27 issue, if that's all right.
Before you move to that,
Oh, sure.
so your point is any conclusion of unconstitutionality should be limited to indigent people?
Exactly, and even then, so people who aren't indigent would still have to pay the fee, and even then, the district court's constitutional violation really was only with them having to pay that fee within that 14-day period. The district court said it indicated at least that it would be constitutional if the department could then come back and collect that fee at a later date. So really, the remedy should be limited to just saying the state can apply that requirement to indigent individuals within the 14-day period.
All right, thank you.
But,
Sure.
but part of the within the 14-day period is that it's a condition preceding
Yes,
to having due process.
that was the district court's rationale, yes.
Okay.
And so if there is a constitutional violation, the state should still be able to recover the fee, just not within it shouldn't be that precondition in order to obtain the hearing. And as long as the person obtains the hearing and receives due process, then there's no
So why
due
is
process
that,
violation.
why is that rational? To make it a condition precedent to get the appeal of an individual law enforcement officer's exercise of judgment, rather than making that a normal circumstance, a cost of the proceedings. In other words, you can't get into court or into review without paying that in 14 days.
Well, I think it's rational in order to ensure that the fee gets paid. If the department can come back and collect it later, that could impose a lot of additional burdens on the department to go after the person for just $50. You're more sure that it will be paid if you make that the precondition.
You're sure it's going to be paid if you make it a condition of getting their license back. That's not an additional burden. They're already paying the reinstatement fee.
Possibly, although then that would be down the road. You'd have to wait, up to a year or so to get that fee back. Whereas here, the hearing would have already occurred at that time, and so getting the fee before the hearing to help defray the costs of that hearing, I think that's at least rational. On the DC 727 issue, the district court never found that Meats was not personally served with that form. Granted, the district court didn't make specific factual findings about how service occurred. What the district court seemed to believe was that, based on its statements, that maybe the officer provided him the form, then took it back and placed it in his property. But in any event, if Meats believed that the district court's findings were insufficient, he had a duty to object, which he didn't do. And even if somehow that wasn't personal service, at least offering him the form and then placing it in his property, that's at least substantial compliance, as the district court found. Substantial compliance should be sufficient. That's normally sufficient under the Code of Civil Procedure and under the Kansas Judicial Review Act. Granted, there's this 25-year-old Anderson case from the Kansas Court of Appeals that held that strict compliance is required, but more recent Court of Appeals opinions have rejected that case. In any event, that case was based on the fact that at the time, strict compliance was required under the KJRA. That's no longer the case. And so even if that case were correct at the time, it no longer is. On the DC 70 issue, I'll just rest on my briefs given that I'm out of time, unless you have any questions on that.
Do you have any questions? Thank you, counsel.
Thank you.
May it please the court, Jay Norton on behalf of the petitioner Warren Meats. The first thing I wanted to do was address a Rule 609 letter that I sent into the court some months back. And at the time that I sent that in, I think I was confused as to the date of the amendment of one of the statutes that I cited in there. I cited KSA 8-1020 subsection P, and that was actually amended July 1st of 2016, which would have been after the evidence in this case. And so it may be of limited value. I just wanted to acknowledge that before I even started here, because I figured that that might be something that you all figured out on your own anyway.
Before you get started,
Yes.
would you briefly address your preservation of your argument that the $50 fee is still a due process violation for non-indigent persons because of non-refundability? Did you preserve that? Can we decide the case on that basis?
Well, I think you can decide the case on that basis, number one, because the Supreme Court's review of the constitutionality of a statute is unlimited. But that is an issue that I raised at the administrative level, I raised at the district court level, and I raised in my responsive briefing to the Department of Revenue's brief in this case. So my intention certainly was always to maintain our position that this statute was unconstitutional as applied to Mr. Meats, even if the court found otherwise. So I may be the least qualified person in this room to talk about what the procedural requirements really are in that situation, but that was certainly what we intended to do.
Assuming it's before us, why is a de minimis $50 fee a due process violation simply because it's non-refundable?
Well, the non-refundability part of it, I think, is very important, because what happens in this situation is that the government takes your property from you. And then if you want to have any conversation about whether that was lawful, you have to pay the $50, which is another taking by the government, whether you're right or you're wrong.
I agree it's eminently unfair, but we're dealing with the law here. And what basis do you have, since we have precedent that says that a fee itself hurdles to gaining a hearing aren't due process violation in all instances, including a fee if it's reasonably related to the cost of the proceeding. And this is a civil matter.
Right. Well, I guess first of all, I would take some issue with whether there's precedent for this particular situation, because I think, as the Court of Appeals found in the Creasy case, there's not actually a tightly analogous case for this situation. The cases that the United States Supreme Court has addressed, and some of the state courts, what they essentially have done, from what I can tell, is they have determined the nature of the interest that is in play, and then tried to determine what is the appropriate due process, or what's the due process appropriate to that interest. And there's been kind of a hierarchy of those interests, which at the top you have things like your ability to terminate a marriage, or your ability to discuss custody of your children or termination of your parental rights. And then down at the very bottom would be something like your right to discharge debts in bankruptcy, or your rights to challenge welfare benefits. The question really in this case, I think, is where does the driver's license rank in that hierarchy of interests, property interests? So to your question, my position would be that in the other cases also, I don't think there's any case where the government has initiated a process against somebody and then said, if you want to have a hearing, you have to pay us money. All the other cases involve whether a person had the right to a free appeal, or they'd been given an evidentiary hearing of some kind first, without costs, without any impediment to their getting that due process hearing. I don't know if I've answered your question here yet, but as
Well, where does it rank? That was the question I asked your opposing counsel. Was we kind of have the privilege, we have fundamental right, we have driving kind of a necessity somewhere in there. Where would you rank it, and how would we apply?
Well, the cases that have talked about driving privileges in the past have said, well, the right to drive is, it's a privilege, it's not a right. But what we're really dealing with here is a property interest, and can the government take your property? It's not whether you have the right or the privilege to drive around on the roads. It's, can the government take some piece of property from you and then charge you money to have a hearing about it? I don't agree with the suggestion that a driver's license is in the nature of a welfare benefit. You cannot use a welfare benefit to get on an airplane. You can't use a welfare benefit to write a check. We use a driver's license to vote in elections. The jury pools are drawn from driver's license records. The majority of the time that we pull a driver's license out of our wallet or our purse is not to show somebody that we have the right to move around on the streets. It's to prove identity, or prove date of birth or residency or something like that. And it's necessary for interstate travel to go to other states.
Well, if someone's license is suspended, they don't lose those other functions, do they?
Well, I don't know how you get on an airplane with the pink form that the
I don't know either. I guess
Right.
I'm legitimately
I think
asking.
there are other.
What happens when somebody's license is suspended? Don't they still have a government-issued ID that says driving suspended on it? What actually happens?
I think you can either use a passport or some other form
Well,
of.
at the hearing, does the judge say, give me your license and cut it up? Like, what actually happens?
What actually happens is at the time that a person is arrested, if they fail or refuse a test in the officer's presence, then the officer keeps their driver's license, which they already have from the traffic stop, and then that's sent to the Department of Revenue.
So if someone's license is suspended, but they still want it for all those other important functions, do they have to obtain a state-issued
They
identification
would
card?
have to-
Is that what has to happen?
Right, they would have to find some other form of identification, which again, I think there's a fee to obtain that.
Counsel, let's take the list that you gave, voting rights, jury pool, that are associated with the driver's license. Are there any cases that have said because of that you can't charge a fee?
No, not that I'm aware of.
So we don't have any cases that say that. What's the closest analogy you can come up with? Is that the marriage case, so that you're equating a driver's license with the right to be married?
No, I don't think that would probably be reasonable. I think it's somewhere in the middle, is my opinion, but there is no case really that says so. There are the cases that, including from this court in this state, that say it's not a natural right, that it is a privilege, and I'm aware of those. But as I've suggested, I think it's more, there's more importance to it than maybe it's been given in the past. And I would also say that at the time.
So there's more importance than, is it like a rational basis plus, or what do we apply if it's somewhere in the middle?
That's what I think the determination has to be, is how much process is due here. And I think at a minimum, when the government, takes somebody's driver's license from them, they should be entitled to have the, basic and pretty bare bones administrative hearing, some kind of evidentiary hearing, in order to determine whether that taking was appropriate or is appropriate. I would also
What
point
you're
out.
dealing with here, in essence, counsel, is if they don't have the $50 in the time frame, they don't get any process, do they?
Right, that's the problem, is that you don't get any process at all. And
It's not how much process is due, it's whether any is due.
well, right, and the issue that's been brought up about if a person is actually innocent or should win on the merits, in just about any other judicial proceeding or adjudicative proceeding, the party that prevails can go and request that their costs be reimbursed, or even assess attorney's fees and things like that in some cases. But there's none of that here. It's a $50 non-refundable fee, and even if you win, you don't ever get that money back in any way, shape, or form.
Let's assume that it's unconstitutional. Is the remedy to simply require the state to pay it back, rather than striking the whole thing down? It just seems like we're killing an ant with an atom bomb here.
Well, the state has suggested that, well, if you find that it's, that it's not constitutional because it discriminates against indigent people or something like that, that you can then, create some exceptions, or say that they should have time to pay, or, it can be tacked on to fees at the time of reinstatement of the license. I don't know really how you do that. The statute's pretty clear and unambiguous, and I don't know how you can really save it, other than to say that we're going to strike the part that says non-refundable and say that there should be a mechanism to refund the fee in appropriate cases, or that people can apply, or that there should be some provision for indigency. So we're going to graft that onto the statute somehow.
Do you know if other states that have this mechanism for administrative suspension have either a reimbursement mechanism or an indigency exception?
There's a case that was cited by the Department of Revenue and the state from Washington, called Didlake versus Washington, which in that state, there is a provision for indigency. And in fact, I think the case said that something like 36% of the people that have an administrative hearing apply for the indigency waiver. But they also said that an indigency waiver was not required by the Constitution the way that they interpreted it. Because they relied on that driving is not a fundamental right and that it's a privilege. I would also, to that issue, say that at the time that some of those decisions were made, I think the Standish case is the one that says that in Kansas, at least says it first. The suspensions at that time in the 1980s, 90s, were 30 days, maybe 90 days. In this case, Mr. Meats has never been in trouble before, never had a DUI before, first time event in his entire life. And in this case, he's facing 1 year suspension, followed by 2 years of only driving with an ignition interlock device in his car. And you have to pay for the ignition interlock device in the car, which the Department of Revenue's website says is about $75 a month. So we're dealing in this case with thousands of dollars and a year of suspension for a first-time offender, if you assume he's an offender. And so I think that my position is that the right that we're dealing with is more important than maybe it's been given credit for in the past, and requires a little more thought about what is appropriate. And my position is that it's appropriate that there at least be some de minimis hearing before that license is taken. Then a person can petition for review, for fuller review, and they have the option of filing a affidavit for, poverty affidavit, or otherwise recovering costs if they win.
Counsel, let me see if I can step through a couple things here. And I hate to use a baseball analogy, but your home run swing here, if you hit the home run, what is that? That there is no fee whatsoever for asking for this hearing?
Well, a home run for my client would be that you dismiss the proceedings against his driver's license and he's not suspended.
But I'm asking your constitutional argument. Are you saying it is unconstitutional to charge any fee to anybody for the appeal? Or are you saying no, what makes this unconstitutional is it's non-refundable? I'm trying to figure out where we are.
Right. My position is that it's unconstitutional to charge any amount of money for a due process hearing in this situation. This has been referred to, at least by the state, as a filing fee. It's not a filing fee. The government initiates the legal action against you. Typically, a filing fee is you want to initiate a legal action against someone else, and you have to pay that fee. In this case, the government initiates an action against you, and this is responsive to the government action of taking your property, whatever interest there is in that property. And my position is that it's unconstitutional to everyone, not just the poor, but to everybody, to charge a fee for that hearing.
And if you were going for your triple,
Right.
it would be all right if it's not unconstitutional to have a fee for this appeal. At a minimum, it should be refundable if you win.
That might be a double, but
We're going to get to the drag hunt pretty soon.
um,
Well, a lot has been said today, and I just am curious if you could restate what your position is on those issues.
well, my position, first of all, I guess the home run position would be that that this statute, this provision of the statute needs to be struck down as unconstitutional, and say, as it's written, it's not constitutional and it can't be enforced.
And to do that, we would have to find that Judge Moriarty was right for the wrong reason, because that wasn't his basis.
I think that's correct. I think
And
Judge Moriarty.
would you agree with opposing counsel's assessment that the $50 fee did not doesn't impact the dismissal in this case as Judge Moriarty made his findings. In other words, he found that that the fee was paid, it was moot, suspension affirmed, but because this mootness exception, we're going to look at constitutionality for indigent people. That isn't involved in this case, but we're going to look at that. And I'm going to make a ruling that for indigent people, this is unconstitutional, at least if it's imposed within the first 14 days and there's no time. Is that a fair assessment?
That was his ruling.
And so I'm still struggling with his ruling was appealed by the state, and the state won. Your client suspension was affirmed.
Right.
Okay, now you've got the cross appeals. I understand that on those two other issues, the DC 27 and DC 70. But how is the $50 dictum ruling legitimately before us?
Well, procedurally, I may have made a mistake by not also including that in the cross appeal section of my brief. But, you know, my argument in front of the district court judge is the same as my argument here today. And so if the court's reviewing his decision with respect to, the argument of the parties, and given that the court's review is unlimited in this situation, I think you certainly can find that the statute's unconstitutional, but the judge got there the wrong way.
I've got a couple of quick questions, if I might, on your cross appeal issues. I don't understand why there wasn't personal service of the DC 27. It was handed to Mr. Meats. He took it, looked at it, set it down on the bench, and then after he had his seizure, they picked it up and put it with his belongings. But what does the personal service require other than personally handing it to the impacted person?
Well, the facts that you're talking about, I think, apply to the Creasy case, actually.
Oh, okay,
that's the case
sorry.
where he had medical condition and all that. I think the facts in this case were that the officer couldn't remember how he provided the DC-27, if he actually gave it to Mr. Meats, handed it to him, or if he just put it in his property. He testified about what he normally does but couldn't remember. Mr. Meats' testimony was, I never saw that document until I was released from jail, which was the following day.
So you're closer to the Anderson case.
So I'm closer to the Anderson case, I think, there. And the court didn't make specific factual findings. The court did specifically find, though, that the officer substantially complied with the personal service requirement. And my position is basically the position of the Anderson case from the Court of Appeals, which is that personal service, the statute says it shall be personal service. And that means what it says.
So you're saying this tees up the substantial versus strict compliance is what you're arguing. On the other, the DC 70, your complaint there is that the warning was that a prior refusal of a PBT would have been incorporated into the warnings. So someone may have thought that if they failed a PBT that they would be subject to this, and that would be more coercive for the driver, but your guys refused. That coercion didn't work on you, and so I don't understand how that makes a difference in this under the facts of this case. I can see where someone agreed to do it so they wouldn't have a crime, but where you refused anyway, what's that got to do with anything here?
Well, My position on it is that that there has to be substantial compliance with the statute, not the form that they give you. The form's just a tool that they use in order to try to comply with the statute. The statute says, you have to tell the person about what happens if you have a prior refusal, and refers to the other statute, which says that doesn't include PUTs.
So your argument is that you have to have substantial compliance even if the non-compliance did not prejudice your client.
Right. Yeah. So I think what you're asking me about is prejudice, and is it relevant here, or does it matter whether this misinformation, if you want to call it that, affected his decision on how to proceed here? About the best I can do is to say that the Miggs case says that if there's not substantial compliance, then no prejudice needs to be shown, that the prejudice is inherent in not getting what the statute requires. I can make other arguments about, well, if you don't get the full story, then there's confusion, and that may affect a person's ability to make a good decision and things like that. But at least the Miggs case says that no showing of prejudice is required if there's not substantial compliance.
Do we have any further questions?
Yeah, I want to follow up on Justice Johnson's personal service question. Is it your position that, there's a line on the form, and there was a line on this form, and the officer signed that he provided personal service to your client. Is it your position that if it's challenged and goes to hearing, the officer has to be able to say that he or she has a specific recollection of handing this piece of paper to this defendant on that night of many nights that they've worked?
Well, I think that that goes into the weight of the evidence. If the officer has certified, I personally served this person by checking the box on the form, and then gets up and testifies, I specifically recall handing it to him, he folded it up, put it in his pocket. Of course, that's a strong case.
So the answer to my question is yes. The officer has to be able to say that he or she specifically remembers handing this piece of paper, or you win.
That's not my answer, because my answer would be that the court can rely on the form and give it whatever weight it wants to. It is a sworn statement, I think, from the officer.
Then why isn't that good enough in this case?
Because the burden is on the driver to prove by a preponderance of the evidence. And if you have just the form that says, I checked that box and provided personal service on that date, and you have another person that says that he didn't, then I think it's a question of who does the court believe.
Okay.
Did your client say he didn't, or did he just say he doesn't remember? But then when questioned, he said, oh yes, I do remember a pink form. I just don't know what it was.
Right.
I think that if you look at the transcript, his testimony was, I didn't see that form. I didn't receive that form, at least, until I was released from the jail. And I think he may have said that he saw that the officer, was handling forms, but none of that was delivered to him. I think he was consistent in his testimony that he didn't get it until he was released from jail. He was cross-examined, and I think that the attorney from the Department of Revenue was successful to some extent in confusing him between DC 27 and DC 70, and him not really knowing the difference between those forms by those numbers. But if you look at the testimony, I think he was pretty clear in saying he didn't get it until he was released from custody.
Thank you, counsel.
Thank you.
On Meats's broader constitutional theories, as I mentioned, I don't think those are properly before the court. But even if they were, he doesn't cite any authorities in support of those. The idea that the fee is unconstitutional across the board is inconsistent with what the U.S. Supreme Court has indicated in Logan v. Zimmerman Brush. There, the court said that filing fees are consistent with due process in appropriate cases.
Your opposing counsel says it's not a filing fee, and that has at least some teeth, right? Because it turns on who initiates the action, doesn't it? And isn't that a distinction from the cases you cite. It may be a distinction without a difference, but that's my question.
I think if there is a distinction there, it is without a difference. Whether you call it a filing fee or an administrative hearing fee, I don't think matters. In Logan, it talked about a filing fee for triggering the right to an adjudication. That's what we have here. I mean, he does have a due process right to an adjudication, at least the opportunity to have the hearing, and they're conditioning that on the paying of the fee. So it is, in that sense, a
But
fee to initiate that.
in those
proceeding.
other cases, the outcome, the desired outcome, was being initiated by the person who was required to pay the fee.
And here,
and here it's not.
well, the hearing is being initiated. The administrative process, I mean, it would be complete upon, if they didn't do anything, their suspension is complete at that point.
Do you think the state of Kansas could simply eliminate the hearing and be compliant with due process?
If there was a judicial process, I do. I think they'd have to provide some process. They wouldn't need to provide, in my
So
view.
they could eliminate the administrative hearing and just go straight to judicial review.
I think that's correct.
And does it matter in this case that the way the statutes are written is such that the individual cannot avail themselves of judicial review unless they first complete the hearing?
I'm sorry.
Exhaust administrator.
I don't believe that's correct. No, if they want the hearing, they request it and say, I'm unable to pay the fee. Yes, they won't get the hearing, but then when that goes up before the district court under the KJRA, they could seek review because that would be a final agency action. They could seek review and argue that fee is unconstitutional at that point. And if they win, then there would be a remand for the hearing that they were denied. So there is that process. The other issue that you were talking about with Justice Johnson regarding the DC 27 and the DC 70, and the fact here that that didn't affect his rights in any way. He relies on Meigs, but the statute itself, if there's a deficient notice, doesn't provide any sort of remedy in this situation. All that the statute indicates is that test results might be suppressed, but even then it indicates that that shouldn't happen if there's technical irregularities, which that's the same language as one of the harmless error statutes. So when, as in this case, it's clearly harmless, as it is, as Justice Johnson pointed out, there shouldn't, failure to provide notice, even if that was a failure, which we disagree with, shouldn't preclude the driver's license suspension.
So you're dealing with Meigs by saying that clearly harmless trumps the Meigs.
Yeah, I mean, Meigs may just be wrong, but even if there's no affirmative duty to provide prejudice, still, if it's clear it's harmless, that shouldn't be a reason for...
And Anderson is wrong also.
Anderson, yes, we think substantial compliance should be sufficient. Although here we do believe that strict compliance occurred. Although the district court didn't make specific factual findings, there's a lot of evidence what the district court seemed to happen. I think happened was that he was provided the form. Even if he didn't personally take it, at least it was offered to him and said, do you want this or do you want it in your property? And it was placed in his property.
And your basis for that is?
The district court's thinking is that at one point the district court commented something to the effect of, the question is if he is given the form, then the officer takes it back. Is that due service? And the court said, I think it is. So based on the court's questions, that's what the court seems to think happened. Now there's a lot of evidence, like the fact that the officer certified that the form was personally served. Although he didn't have an independent recollection of that, at the judicial proceeding, which was close to 2 years later, the administrative hearing based on Meigs' counsel's questions, he apparently testified that's what happened. He said that's his normal practice, is to give them the option, do you want this now or do you want it placed in your property? Offering them and then place it in their property, that would be personal service. And so strict compliance occurred. But even if it didn't, substantial is sufficient. Was there any further questions?
Any more questions?
I would just urge you to reverse the district court on the constitutionality of the fee and affirm the suspension. Thank you.
Thank you, counsel. I thank you both for your arguments on this case. We'll